is going to be on the Case Act and the Copyright Claims Board. I'm going to go ahead and get started and provide some background into the Case Act and then turn things over to Maya to give us some information about what's going on with the CCB's implementation. All right. Okay, so the Case Act, for those that do not know, stands for Copyright Alternative and Small Claims Enforcement Act of 2019. And just to give some background about the need for the Case Act, so as most of you probably know, federal courts have exclusive jurisdiction over copyright claims, which in turn means that if you are a creator and you have an infringement action or anything like that, that you need to take to court, you are basically bound to only take that to federal court. The main problem with that is that federal court is incredibly expensive. I'm gonna get a little bit more into that, in detail into that in a future slide. But so that in turn really makes this, in my opinion, an access to justice issue, because basically creators who own rights to copyright have these rights, but they essentially have a right with no remedy. And just, I'm going to take a pause for a second because I just realized I failed to introduce myself. My name is Terica Carrington. I am Vice President of Legal Policy and Copyright Counsel with the Copyright Alliance. I think I have the ability to turn, oh, nope, I still cannot turn my video on. So I will keep going.
Try it again. I just turned mine off just in case it was me.
Nope, I'm still getting the message that I cannot start my video because the host has stopped it. So I will try again a little later. Okay, so again, so I see this as an access to justice issue because we have creators who have rights, federal rights under copyright that actually do not truly have a remedy to be able to enforce those rights. So that brings us to the Case Act. So what the Case Act does is it establishes a small claims tribunal that is going to be housed within the Copyright Office. This tribunal is going to exist as a voluntary alternative to federal court, and I'll kind of get into that a little bit more in a future slide as well. Available for certain copyright claims, not all copyright claims, but there are 3 specific ones that are going to be available to bring before the CCB, and with a limitation on permissible damages, which is what makes this a small claims tribunal. So on this slide, I'm just kind of talking about the broad support for the bill that existed. Copyright is generally a pretty bipartisan issue, and that does not stop with the Case Act. As you can see, there's a broad swath of organizations that supported the Case Act as it was moving through Congress. And I think most notably, these are organizations that are not typically on the same side of various legislation. Oftentimes you see them kind of opposing the same legislation. For example, the AFL-CIO, the American Conservative Union, shout out to IIPSJ, the NAACP, and others. So the Case Act was officially signed into law on December 27, 2020. The bill initially was supposed to have the CCB open its doors as early as December 2021, 1 year after the bill was passed, but it also contained a provision that allowed the register to delay that by 6 months if it was necessary for any reason, and the register did invoke that privilege. So right now, the Copyright Claims Board is set to open its doors by, I believe, June 25th is the specific date, 2022 at the latest. So some background about how the Case Act kind of came to be. So I think for a lot of people, they've just kind of started to hear about the Case Act in recent years, but it's actually been kind of percolating for at least, more than a decade. Going back as early as 2011, the House Judiciary Committee chairman at the time, Lamar Smith, asked the Copyright Office to do a study on the need for a small claims system or potential remedies for small claims actions. And then in 2013, after a 2-year study that the Copyright Office did, they released a very comprehensive report that was over 200 pages, I believe, and they touched on a lot of different background issues. They looked at the current federal landscape and kind of identified problems there that exist as far as small claims remedies and trying to bring smaller actions. They looked at state courts and whether or not there was a potential to address those issues through state courts. They looked at other administrative bodies and whether or not they could kind of offer some insight into how to address this issue. And then finally, they ended with some recommendations, including actual text that became the basis for the actual legislation for the Case Act. So the first iteration of the Case Act was introduced in 2016, and since then, 2 more versions of the bill have been introduced. In 2019 was the first time that the bill was introduced in both the House and the Senate. I'm going to kind of skip through some of this background here and bring us into 2020, which is when the bill actually passed in December 2020. Congressional leaders decided to include the Case Act in a year-end spending bill, and that was pretty much motivated by the fact that the bill had gotten such great support in general through Congress, but it was being held up by one senator. And so the bill was passed in December of 2020. And I'm just going to touch lightly on this because Maya's going to get a little bit more into this, but what basically went on in 2021 is the Copyright Office started to do implementation procedures, as well as hiring staff for the Copyright Claims Board. So that includes the Copyright Claims Officers, who are basically the judges for the tribunal, the Copyright Claims Attorneys, which Maya is one of those, who is going to be like assisting parties who are bringing claims to the process to kind of understand what they need to do to actually get the process started and continue throughout that. And the Copyright Office also began the rulemaking process by issuing a notice of inquiry, kind of a broad notice of inquiry about various issues related to the CCB. And then they followed that up with various notices of proposed rulemaking on specific topics, including expedited registration in FOIA, small claims procedures for libraries and archives opt-out, and then some of the specific procedures for initiating a claim, and then also the details about what happens after you initiate that claim and it becomes an active proceeding. So as I mentioned previously, the doors to the CCB will open by June 25th, 2022. And what are some key components of the bill? So I touched on this, I think it was the first or second slide. It is voluntary, and that's for both parties. And so what that means is, if you are a claimant who has a claim that a copyright claim that you want to bring, you still have the option to bring that claim in federal court if you so choose and if you can afford to do so. But alternatively, now with the Case Act, you have the option of bringing that claim to the CCB if it is in fact a small claim and qualifies in the other ways, such as like is the type of claim that you can bring before the CCB. And on the other side, for respondents, it's also a voluntary process. So it is an opt-out procedure. So you do not have to participate in the small claims process. And so the number one question that I get when that topic comes up is, well, why is it voluntary? Why is it not, required like a federal court case would be? And the reason for that is due to constitutional issues, because this is not a tribunal that's actually housed within the judicial branch. There have to be voluntary considerations in order to make it constitutional. So that's one of the key components for the bill. Also, it's a simplified and streamlined process. So kind of going back to the issues about social justice and accessibility, this is a tribunal that's designed for pro se parties to actually be able to represent themselves. So one of the most significant costs associated with litigating a copyright case in federal court, and this was actually touched on in that comprehensive report that the Copyright Office did, one of the most extensive parts of that, expensive parts of that cost deals with actually hiring an attorney. And so by cutting out the fee for actually having to hire an attorney, it makes this process a lot more accessible and affordable to your average pro se person. Also, no travel is required. So even though the tribunal is housed in the Copyright Office, which is in DC, you're not going to be required to actually travel there. Everything is pretty much going to be handled remotely. And then another thing that I think is really awesome and unique about this process is that the bill itself allows for pro bono assistance by law school clinics. And what I think is really important about that is, again, it's really expensive to be able to hire an attorney. So most parties that come before this tribunal are likely not going to opt to hire an attorney. However, at the same time, they may want to have some legal assistance, some sort of expertise and guidance throughout that process. And so I think the ability for law students to sort of step in and fill that gap will help to make this a much more accessible tribunal for parties that need access to justice, but just can't afford an attorney and maybe don't necessarily feel comfortable navigating the process by themselves. So the limitation on statutory damages for the Case Act is $15,000 per claim, which you compare that to up to $150,000 in federal court. So it's 10% of what's available in federal court per claim. And then unlike federal court, where there is no overall limit on the amount of damages that a party can receive, in the small claims process, there's a total overall cap of $30,000 per case. And the types of claims that can be brought before the CCB are going to include copyright infringement claims, as well as declarations of non-infringement, and DMCA 512F misrepresentation claims. So that deals with like the notice and takedown process. If you receive a notice or receive a counter notice that you feel has some sort of misrepresentation, you can actually bring that case here as well. And I just want to note that, you know, I have been speaking on behalf of creators because the organization that I work for, the Copyright Alliance, we represent copyright owners and creators. However, as you can see by the types of permissible claims available before the CCB, this is actually a tribunal that is accessible and designed not only for creators, but also users of copyrighted works. And so, you know, with those declaration of non-infringement claims, as well as F512F claims that are available, this is important not just for copyright owners and creators, but also for users of the system who likewise, you know, are going to likely struggle to be able to afford to bring a case to federal court. And then I just want to quickly kind of touch on some of the safeguards that exist. I know, and I believe it was the first panel, Ian kind of mentioned that some concerns that people have about, quote, trolling. And, you know, that is a concern that I have heard before. I have to be honest that I don't think it's a very legitimate concern. I think when I kind of get into some of these safeguards, I hope that'll kind of become more clear. But I think the context of this particular tribunal is one that is not really conducive to trolling, especially when you compare it to federal court. So for instance, this is a process that's entirely voluntary. So if you feel that someone is bringing a claim against you that is not a legitimate claim, unlike federal court where you have to defend against that claim, in this tribunal, you can choose to opt out. And if you opt out, it doesn't mean that the case, you know, automatically goes to federal court. There are no penalties for opting out. The case is done. It's dropped and it's done. And so I think that's one big reason that makes this not a tribunal that's going to be conducive to trolling. But I think in addition to that, when you bring a case here, it's not free. So you do pay a filing fee. And so I think if you were someone who wanted to, you know, operate under a trolling type of business model, it really wouldn't make sense to pay a filing fee to bring an illegitimate claim against someone where they can just opt out and then you just foot the bill for no reason. So that's not really something that I think is a legitimate concern. I think for the most part, that's a concern that I've heard from organizations and people who kind of have a general stance against anything that supports creators being able to enforce their rights, which obviously the Case Act is something that is designed specifically to allow more creators and more copyright owners to be able to enforce their rights because they couldn't afford access to federal court. The notice requirements under the Case Act mirror the requirements of the Federal Rules of Civil Procedure. So there's not an issue with getting notice that is going to be some sort of, you know, random email or, you know, just all these kinds of like a phone call or different things that I saw sort of online where people were, I think, fear mongering to sort of make the Case Act seem like it was going to be something that was going to be just targeting random people and putting people in these bad positions. I don't think that that is a legitimate concern either. In addition, there are penalties for bad faith claims and actors. You can be banned for up to 12 months from using the tribunal if you're found to have acted in bad faith on more than one occasion. You can also be required to pay attorney's fees and costs if you are found to have acted in bad faith or brought a claim for a harassing or other improper purpose. And then finally, the Copyright Office has the ability to limit the number of cases that a particular claimant can bring before the CCB. So I think that just kind of goes to show there are a number of safeguards. This is a tribunal that, you know, creators and copyright owners have really wanted for a long time. Small creators and copyright owners have really wanted, and they do not have any interest in having this be a tribunal that is overtaken by illegitimate and trolling behavior. This is something that they want because they truly have a need for it. And so with that, I'm going to stop sharing my screen and turn things over to Maya to kind of talk about the implementation process of the Copyright Office.
Can you hear me now? Okay. And slides are good? Everybody can see my screen? Okay. So first, I want to thank IIPSJ for hosting this conference. As a Howard grad, it's really my honor to be speaking here today. And I also want to thank Terica for doing such a great job explaining the history of the CASE Act and what the CCB is, because it makes my work of discussing our implementation just that much easier. As Terica mentioned, my name is Maya Burchett. I'm going to be one of the copyright claims attorneys working with the CCB. So Kstack implementation. So implementing the Case Act has been an endeavor that has involved many different parts of the Copyright Office. As Terica mentioned, the statute gave us 1 year plus 180-day extension to get the CCB operational. So we've really had to hit the ground running, which we know can be really hard for a government agency, which is kind of used to taking its time. To that end, I like to think about the implementation of the Case Act in 4 main areas: staffing, regulations, technology, and resources and outreach. Last week, we onboarded the last of our staff members, and the CCB now consists of 3 copyright claims officers, David Carson, Monica McCabe, and Brad Newberg, 3 copyright claims attorneys, including myself, Whitney Lewandowski and Dan Booth, 1 paralegal, her name's Laura Kaiser, and 1 program specialist, Natalie Cronin. I've also included our implementation tracker here, which you can find on our website at copyright.gov. So as Terica noted, the Case Act was passed in December of 2020, but didn't detail a lot of the specifics of every system and process needed to get the CCB operational. The Act left a number of things up to the office's regulatory authority, including how to file a claim, discovery rules, smaller claims proceedings. So those are going to be proceedings that involve less than 5 claims that involve less than $5,000. Fees, controlling bad faith actors. The statute kind of left that up to the regulatory discretion of the office. So we asked for an initial round of public input on all of these things, and then issued 5 very specific notices of public proposed rulemaking, which further lay out the rules and processes for the CCB. So everything from how much the fee is to how law students can practice before the board, and solicited another round of public comments on these specific procedures. So for instance, the small claims and expedited registration procedures will govern pending copyright registration. So if you're a creator who has a pending registration, how do you ask the CCB to expedite that registration? That's what that first rule is going to cover. Initiating procedures. That rule tackles the procedures to initiate proceedings, including service, opting out, filing response. How do I file a counterclaim? Active proceedings and evidence covers a variety of procedures, including what does written testimony look like in the CCB? How do parties ask for a conference, hearings, discovery, and the conduct of parties, which Terica touched on as well. Lastly, we also issued a rulemaking governing representation by law students and business entities. That's going to govern how law students can participate before the CCB. So moving on to technology. Another thing we had to consider is how people would file, respond, and participate in CCB cases. We're currently developing eCCB, which will be the online case management system. The form will walk claimants through explaining and identifying the work at issue, explaining their claim, attaching any documents that you want to have to prove the case, and paying the fee. The system will also allow respondents to opt out or respond to the claim and include their defenses. Similar to that, we're developing a designated service agent database where business entities can elect to receive CCB claim notices and other documents via a designated service agent. So if you have a business and you want to receive notice of your CCB claim in a specific way, registering for the designated service agent database is going to be the way you're going to do that. Next bucket. Next bucket is resources. So as I mentioned, our last bucket of implementation kind of materials is going to be resources that will assist people in filing and responding to claims. We're in the process of drafting a handbook, which is going to be a step-by-step guide to navigating the CCB. But handbook and forms are just one of the various materials that the office is developing. We're working on creating checklists and visual aids for the website, instructional videos. We're in the process of creating a dedicated CCB website, which will include a portal to eCCB, which I just talked about, that designated service agent database. So if you do want to file a CCB claim against a business, that's going to be your first place to check and see if that business has a designated service agent. The libraries and archives opt-out list, that's going to be libraries and archives can preemptively opt themselves out of a CCB proceeding. If you're thinking about filing a claim against a library or archive, you can check and see if they've already opted out. I talked about the handbook a little bit, and educational resources and graphics and tutorials. We're working on creating those. And as I mentioned, we're working on creating handbook and forms. We're also working on creating a number of other materials. If you're like me, you can see a comprehensive guide to how to do everything and get a little overwhelmed. That's why we're making sure that we're creating resources to walk participants through every step of the process. And creating visuals. That way, we're reaching people where they, and giving people information how they learn best. The last thing I want to mention is I would be remiss if I didn't mention our About Small Claims page. That's currently where we have all the office's information about the CCB. You can visit that at copyright.gov/about/small claims for the history that Terica talked about, facts about the CCB, FAQs, and that implementation tracker. And you can also subscribe to our Newsnet service, which will give updates via email in your inbox like a newsletter about what we've implemented and when we're going to start accepting claims. And with that, Terica and I are going to talk a little bit more about some of the conversations surrounding the CCB. Terica, can you? Yeah, someone at the webinar support wants to take Terica off of mute.
Okay, great. Back in action. Okay, so this portion, Maya and I are kind of just gonna have a little bit of a discussion about the implementation process. We're gonna start off by, I'm gonna bring up some of the concerns that the copyright community has had with some of the regulations that we've seen so far, and to the extent possible, Maya is going to kind of respond to that. And so the first one that I wanted to raise, and I think this comes from, I believe it was like the second or third NPRM that came out on initiation of proceedings, but it proposes a $100 filing fee. So as I mentioned before, when I was talking about why I don't think this is a tribunal that's conducive to trolling, I mentioned how it's not free in order to file a claim. So you do have to pay a filing fee. And the proposed filing fee that the office has proposed in the NPRM on initiation of proceedings was a $100 filing fee. And the CASE Act legislation, it sort of sets up that the filing fee has to be no less than $100 and no more than the cost of filing a claim in federal court. In the legislative history that accompanies the CASE Act, the Senate report, it actually kind of breaks down what they envisioned by that $100 filing fee. And what they said basically is they suggested a tiered filing fee. So because the CASE Act, or because the CCB is a voluntary tribunal, and parties have the ability to opt out, they suggested, you pay an initial fee, so let's just say $25. Once the party does not opt out and the case becomes active, at that point, the claimant would pay the $75 or whatever is the difference in that $100. And I think that is an important mechanism because of the fact that this process is voluntary, and because of the fact that, again, it was designed for parties that cannot afford federal court. And so I think a process where people are paying $100 and, the respondent opts out and they lose $100 and they don't get anything in return for that, kind of puts them in a position that it's actually a little worse than federal court, where you pay $400 or whatever the fee is, and at least you get into court. Of course, you have a lot of other fees that come along with that as well. But I think that's one of the biggest concerns for the copyright community, because that $100 is actually designed to be the fee for the entire process, start to finish. And so the idea that people would pay $100, the other party could opt out and you get nothing in return for that is one of our biggest concerns. I don't know if you want me to kind of just go through all the three things that I was planning on talking about, or if you want me to kind of pause and let you.
We can pause so that way we can talk about each separately. But so I'm just going to do a blanket. I can't talk about the final rule that hasn't been published yet. So I can't exactly comment on filing fees. But what I can say is that there were 142 comments on the fee issue, more than we received on any other one specific topic. And we read every single one of those public comments that we get. And it's a great thing kind of about proposed rulemaking, is that we can put something out to the public and the public can react to that, which they have. And so what I can say is that when we do publish that our initiating proceedings regulations, that they will be responsive to the numerous comments that we have about the topic that Terica raised for the issues that she mentioned.
Okay, great. Yeah, and I did notice, because I read the filings as well. And I did notice that a lot of individual creators themselves did also file and kind of express, concern about that fee. So very, very happy to know that you all are kind of taking a look at that. And also, I just want to pause for a second and just to thank you and the rest of the team at the Copyright Office, because I know you all have been working extremely hard on implementation of the CASE Act, among a million other things as well. And so we're greatly appreciative for all of your hard work on that. So that was the first issue that I wanted to kind of raise. The second one deals with not the most recent, I think the most recent NPRM was a law student one, but the one right before that on active proceedings. This was a concern that we had, and our filings have been joined by numerous other organizations as well. I think that particular one on active proceedings, I think, was joined by like 19 other organizations. But so when I say we, I mean like all of the organizations that were signed on as well. A concern that we had with that particular NPRM was just the overall complexity of the procedures. And more specifically, I think there's a couple of issues there. One is the language that's used throughout the regulations. I think there's a lot of legalese, and there's a lot of sort of reliance or close ties to the federal rules of civil procedure. And I think the concern that we have with that is, again, that this is supposed to be a proceeding that's going to be accessible, and that we expect most people will choose to use without the assistance of an attorney. And I think that kind of even just opening up those regulations and seeing some of the language that's used is going to be very intimidating to parties who don't have any sort of legal background or don't have a lot of experience with the law. Is going to be a concern. So that's one part, the language itself, but also in addition to the language, because I think to some degree, the language is the easier part to address. I think this is a little bit more of the difficult part. I think some of the actual procedures outlined are a little complex as well, due to their reliance on the federal rules of civil procedure and the federal rules of evidence. Like, for example, I know there was some references to like cross-examinations, and they talk about requests for admissions and interrogatories and things like that, that, you know, legal professionals understand, but your average, you know, creator or user of copyrighted work who's just trying to bring a claim is probably going to be intimidated by. And just to kind of tie this back to, you know, the whole theme of this conference, social justice and access to justice, you know, I think it's important that we take every effort to make sure that this tribunal is accessible in every way possible, including not just financially, but as far as the ability to actually understand and really navigate the process itself. Just looking back at my notes. So yeah, that's pretty much sort of our concern with the complexity of those regulations, and in particular with like discovery proceedings and things like that. One of the things that we talked about in the comments that we filed to the Copyright Office in response to that NPRM was the fact that, so I didn't talk about this in my opening like slides, but there is also what is, I think the Copyright Office is calling like a smaller claims like section of the CCB. So there's the small claims that you can bring $15,000 per claim or less. And then there's a smaller claims for $5,000 or less. And, you know, some of the suggestions that we made is for those like smaller claims, or I prefer to call them micro claims just for the sake of confusion, but for those micro claims, that the discovery regulations be even more simplified than the broader small claims processes. So for instance, this could truly just be a paper sort of process where, you know, claimant explains their concerns, respondent responds. There really doesn't need to be discovery for those smaller claims, unless for whatever reason the CCB thinks that, you know, there's a special case and a party has asked for discovery. Maybe they could consider it in that case. But an idea that we had was that, you know, for those micro claims, actually just getting rid of discovery and really ratcheting down the complexity of the process. So that was just our second concern that I wanted to throw out there. And I know you made your blanket statement, so.
Well, for the sake of my public affairs specialist who's on this call somewhere, I'm going to again reiterate that I can't talk about rulemaking that we're currently, the process of rulemaking before the rules are final. But what I will say is that to touch on a couple of points that Terica made. One, yes, there's going to be a process for smaller claims. And one thing I've really realized working with the CCB is that we have a lot of words that are like the root of a word: claim, claimants, response, smaller claims, smaller claims. But yeah, so the smaller claims process is going to be for claims that are less than $5,000. And we're hoping that when our rulemaking is finalized, that, you know, we'll address some of the issues that that the public raised in that active proceedings comment. But what I will say, a conversation we've had internally regarding the complexity of navigating the CCB process is just being really open to where we're meeting people, potential claimants, potential respondents, potential users of our system in the process, whether that's meeting a potential claimant, you know, what do our resource materials look on our website? Are they approachable? Because yes, there are going to be certain things that all of us lawyers know and understand, but how do we distill those topics and distill that information down for the public? And we've been working very, very closely with our outreach division of the Copyright Office to really talk about what we can give people at different phases of the proceeding to make sure that everybody understands where they are in the process, what they need to bring. We're talking about doing checklists. We're talking about doing tutorial videos. We're talking about, you know, everything is on the table right now as far as how do we distill this very, very complex information down for pro se users. And to that end, where are we meeting our constituency at, and viewing our constituents as people who will use the CCB, whether they be creators who want to file claims, whether they be business respondents. Like, how are we talking about these processes to the public is something that we've had a number of conversations about. And again, you know, proposed rulemaking is proposed, and the rules will look different than the proposed rules that we published originally.
Great, thanks, Maya. And then the last thing that I just wanted to raise as far as like the copyright community's perspective on some of the proposed regulations that we've seen so far. So earlier in my presentation, I touched on, when I was talking about safeguards that exist in the CASE Act, I talked about how the Copyright Office has the ability under the actual statute to limit the number of cases that a claimant can bring. And in the proposed regulations, they do invoke that ability to do so. They propose a limit of 10 cases per year or per 12 months for a claimant. And the concern that we have with that is not so much about the decision to limit the claims, but more so how the claims are limited. So the proposal is that the claims will be limited to 10 claims filed as opposed to 10 claims actually heard, which has the effect of potentially meaning that a claimant could bring 10 cases, the person opts out all 10 times, and they don't actually have the ability to have an actual case heard. And because of the fact that, you know, the CASE Act, you know, came about because essentially because of that exact same reason, you know, these people are unable to have their cases heard in federal court today. So we have a big concern that, you know, while I understand the rationale that the office gave was, you know, that they're hoping to be able to control their docket and make sure that everyone has an opportunity to have cases heard, and that, you know, no one party is sort of overwhelming the resources of the CCB, which I think makes sense. But at the same time, I think if they could actually tie that limitation, you know, to the extent that they, you know, think it's important to have a limitation, tie that limitation to cases actually heard. So 10 cases, like actual real cases before the CCB, as opposed to 10 cases filed, I think that that would be a big benefit. And just to add to that, I think, you know, when you look at each one of the three things that I've highlighted on their own, I think they are kind of concerning individually, but when you look at all three of them together, so, you know, this $100 filing fee, you know, a pretty complex set of, you know, procedures, and then you have the ability to file 10 cases and never actually have a single case heard, and then you're kind of prevented from having the case, having another actual, even filing another case for however many more months are in the 12 months. I think all of those things in concert sort of have the opposite effect of what the CASE Act was supposed to do, which is to make this accessible to people. I think it has the effect of really making it inaccessible. And so that's something also that we are hopeful that the office can kind of reconsider, because again, we do understand a need to balance your docket, but I think there's hopefully a middle ground that can kind of be reached with regard to that.
So for those of you guys watching who aren't as entrenched in the rulemaking process as Terica and I are, what she's talking about is something that is in our active proceedings rulemaking. So if you guys want to go back and review that, that's exactly where that is. Again, I can't comment on anything that hasn't been published as a final rule yet, but what I can say is that, you know, this has been a really interesting process because one of my colleagues calls it, it's like building a car while you're driving the car. And so we are, that's one of the reasons that this public feedback is so important, is because we talk about this to each other, with each other all day, every day. We can get really entrenched in the system. And one of the things that we've always realized, but is, you know, ever more apparent now that our proposed rules are kind of out in the world, is that, you know, we don't know what we don't know. We won't know how many cases that the CCB is going to get. Every day somebody asks me, every day I say, we have no idea. So we're hoping that it's a use to, you know, we're hoping that it kind of closes some of the gaps that Terica talked about in her presentation. We're hoping that we can address this access to justice issue. We're hoping that we can, we have a wealth of pro se parties, a wealth of pro se respondents that, you know, people can address these copyright disputes without the time and expense that it takes to engage in federal litigation. At the same time, we don't know yet what our capacity is going to be to hear all those claims. So that's something that rule kind of addresses. And again, when the final rule comes out, I think that it's not going to be necessarily set in stone. Rules are something that can be changed as we get a better idea of how many cases and claims that the CCB will hear every year.
Great, thanks, Maya.
We're still very committed to making sure that this is accessible for everybody and that everybody has some access to the CCB. So I did see some questions come in. Let me see if I can pop that up.
I see this question about voluntariness. Is that the one you were looking for?
Yeah, if you want to go ahead and read it for everybody.
Yeah, so the question says, I guess it's a two-part question. One, by voluntary, do all parties involved have to consent, including the alleged infringer? And the $30,000 is the max in total, even if more than one copyright registrations are at issue. Did you want to take this one?
Yeah, I can. So yes, all parties have to consent. So if the alleged infringer, which we're calling a respondent, if you receive a notice of a CCB claim, you can opt out or you can do nothing, and then you will be in a CCB proceeding at that point. $30,000 max total, even though one copyright registrations are at issue. So yeah, the total cap of a CCB proceeding is going to be $30,000. If you're looking at statutory damages, it's going to be $15,000 per work.
And if I can just kind of piggyback off that a little bit, because just going back to the first question about voluntariness, do all parties have to consent? A lot of times when I hear this question, the immediate follow-up is, well, why would an alleged infringer participate in this if it's voluntary? Why would they not just all opt out? And the answer that I have to that question is, again, because this is a small claims proceeding, the liability is significantly limited compared to the potential liability that you have in federal court. And although most parties can't afford to go to federal court, that doesn't mean that all parties can't, or that doesn't mean that they cannot get some sort of pro bono representation. You don't necessarily know the means that a person has when they bring a claim against you in the small claims process. And so for a person who, let's say in particular to this question, someone who is an alleged infringer, they have an infringement claim brought against them, if they do a calculus, about whether or not they are potentially liable, and they realize like, okay, hey, wow, yeah, I did potentially infringe that work. I didn't mean to, I didn't realize, what I was doing, but hey, I did infringe those rights. And if I go to federal court, I could potentially be on the hook for a significant amount of money. It may make sense for a person in that position to make the decision to participate in a small claims process rather than take the risk of ending up in federal court. And I think that's going to be a calculus that's made from someone who is not just like a bad actor. So if you're talking about someone who is just makes a business model and a regular practice of infringing people and other works, I think that more than likely they are not going to choose to participate in a small claims process. But I do think, on the other hand, there are others who find themselves having, infringed the rights of someone else, caused them harm in some way, maybe didn't intend to do so, but they still did, and find that they could potentially be liable for however much money, and really want to decrease that potential liability and take the safer route and participate in the small claims process. So even though that question wasn't asked, I just have a feeling people are kind of wondering and thinking that. So I just wanted to kind of anticipate that.
Yeah, that's the natural follow-up question. Another thing to note too is that, Terica and I have both been hammering home how long the federal litigation process can be. We're hoping that a respondent, may choose to participate because if they are, they can just say, hey, I can wrap this up and get this over with in a much quicker time frame and have it off my back, rather than participate in federal litigation, which is mandatory and has, takes an extremely long amount of time.
And I don't see any other questions, but if other questions pop up, we can answer those. But I just wanted to kind of quickly talk about some of what we're doing at the Copyright Alliance to sort of help individual creators get prepared for this system. So I know Maya mentioned that the Copyright Office is coming out with a handbook to sort of help people to navigate the process in an easier way. We have been working on something similar. We have been working on a guide for individual creators to kind of understand the Kstack and understand the procedures that they're going to have to navigate in order to bring a case and kind of from start to finish. So that's something that we have been working on for a while, actually, even before implementation came about, sort of giving people a 100-foot view or whatever the phrase is of the process, that they could kind of understand things. And as the regulations continue to come out, like the final rules continue to come out, we're going to be diving into them and deciphering them and turning them into language and processes that we think are most understandable to individual creators and people that just don't have like a legal background. So that's something that we're continuing to work on. And so far we have made that available to Copyright Alliance members. Another thing that I just kind of wanted to touch on is that we have a project that we are getting off the ground now that is going to be a project to help creators of color register their works. So as many of you may know, you are required to have a registration in order to enforce your rights in court. It's pretty similar, not exactly the same, but pretty similar under the CCB. So you don't have to have a registration in hand in order to file a claim at the CCB, but you do have to have that registration before the board actually issues a determination. And so we anticipate that, more creators are actually going to seek to register their works because, they actually have the ability to enforce those rights now. And a particular project that we're trying to get off the ground is having and helping creators of color specifically to be able to register those works for free. So we will be launching that program at some point later this year. People will be able to apply. We will have people assisting them in actually doing the registration process, as well as pro bono assistance to actually do the registration. And the goal of that project is twofold. Number one, obviously, to help them get their works registered, but on a more broad scale, to educate creators of color about their rights, about the fact that they do have rights. I mean, I think a lot of people assume that, like in the patent system, you have to register a work before your rights sort of kick in. And I think a good sort of side effect of a program like this is that it will help creators to understand that they actually do have rights immediately. As soon as that work is created, you actually do have rights that are enforceable. And so we are open to, if anybody in the audience is interested in being a part of that, I'll drop my email address in the chat and you can reach out to me whether you want to participate to do pro bono assistance with registrations, or if you would like to donate to actually help fund the project, we're open to that as well. So yeah, just wanted to throw that out there as far as what we are doing.
Looks like we got one more question in here. You mentioned earlier that the Act finally gained support from Congress in 2020. What led to the change?
That's a good question. So I think, to be honest, it had a lot to do with the fact that people who were proponents of the legislation and proponents of the small claims process, who have been doing this much longer than I have, they slowly were gaining traction over those years. And so the issues first started to come to light back around 2011, as I mentioned. And it seemed like, every couple of years or so, more people became aware of the need for this. And just as more people became aware of it, and as they continued to, go to Congress and explain why this was an important issue, I think that actually helped traction a lot. And I think also the fact that people saw this truly as an access to justice issue. So I think we're probably all aware in 2020, a lot of people sort of had light bulb moments where they started to recognize the importance of issues like access to justice and other related social justice issues. And I think truly the fact that this really does come down to people having rights, but not really being able to enforce those rights simply because they can't afford to do so. I think that kind of turned the light on for a lot of people and helped to get the Kstack across the finish line.
Yeah, and I also take I hate this word, to piggyback off of what Terica said, it's, I think that the first step in you know, the access to justice problem is knowledge and information. And, you know, a lot of groups were able to kind of, while everybody was at home, talk about these issues and these disparities that they were seeing. Speaking of knowledge and about an issue, in the chat, there's a link to the copyright.gov/about small claims. That's going to be it's our current one-stop shop for the copyright.gov about the CCB. There you can sign up for our Newsnet, which will have more information about when we're coming and when all the resources that I talked about in my presentation will be available to the public. I don't see any other questions coming in.
Yeah, if I can just kind of add, I guess I'll piggyback to your piggyback to that question. Another thing that I was just thinking of, I think in general, a lot of times when people think about copyright and copyright owners, they immediately, their minds go to big corporations and, you know, producers of big content, movies, music, software, things like that. And they kind of overlook the individual creator. And I think in reality, most creators are not celebrities. They're not super rich, you know, people. Those are the people that we know of mostly because of their fame and notoriety. But there are a lot of just regular, everyday, middle-class creators who have, they deal with infringement the same way, you know, a Jay-Z, a Beyonce deals with infringement. And yet they don't have the same resources to be able to access court. And so I think helping to illuminate that fact to people in Congress and just to society more in general, I think that helped them to understand, okay, why is this issue important? If you're only thinking of copyright owners as corporations with big, deep pockets, it's kind of, it doesn't quite click. It doesn't quite make sense. Well, why do we need this small claims process? But I think once people realize, you know, most creators are, you know, people of, you know, modest means that don't necessarily have, I don't even know if I touched on a specific statistic, but when the Copyright Office's small claims report came out in 2013, they cited a statistic that the cost of litigating in federal court from start to finish at that time was around $350,000. I don't know who just has $350,000 laying around to enforce a single copyright, or 10 copyrights, any amount of copyrights. Today, that statistic is closer to $500,000 or more. And so your average person, those numbers are numbers that corporate entities are going to be dealing with. It's not going to be individual creators. So I think, you know, a lot of things kind of came together in good timing, and that kind of led to the passage of the CASE Act.
So I see we got our moderator back, which means we're probably cut off. So
yeah, we're getting kicked off.
But I will say that it was great speaking with you, Terica, and I will note that if anybody has questions for the CCB that I can or cannot answer yet, go ahead and email us at asktheboard@ccb.gov. And I am as well
dropping my email into the chat as I promised I would. And thank you so much, Maya. It's always great to work with you. And I also just want to thank the folks at IAPSJ for having us. This is always a great time working with you all as well. Glad to be here.
Thank you so much, Terica and Maya. I'm going to share now the CLE code for the attendance verification code for this session, and that is diversity. And in the meantime, we will get the next panelist up to queue.